In the midst of President Johnson's Great Society, Ronald Reagan explained that our nation had arrived at a crossroads, at a time for choosing. The choice, Reagan explained, was, quote, whether we believed our capacity for self-government or whether we abandoned the American Revolution and confessed that a little intellectual elite in a far distant capital can plan our lives for us better than we can plan it for ourselves. 40 years later, our nation once again finds itself at a crossroads. Government is getting larger and larger, spending is out of control, and a little intellectual elite in a far distant capital is trying harder than ever to plan the lives of the American people. Even basic choices about how we care for our own health are now made by career bureaucrats whose names Americans will never hear and whose faces they will never see. Our nation has a choice to make. We either restore or relinquish our great heritage of limited constitutional government. Part of that choice will be made here today. Part of that choice will be made as we consider the nomination of Elena Kagan to the Supreme Court. In recent years, the progressive wing of the Supreme Court has authored opinions that would have denied Americans their right to keep and bear arms and severely diminished the right to free speech during election time. These same progressive justices succeeded only a short time ago in ruling that a citizen's property could be seized by the state for private commercial development. These justices are ignoring the text of our Constitution, the plain rights guaranteed by our Constitution, in order to advance what they think are better ideas, their vision, their political agendas, frankly. This progressive, activist judicial philosophy strikes at the heart of our democracy and is a direct threat to our liberty. Judges are lifetime appointed. They're not accountable to the people. President Obama himself has said that judges must shed their neutral constitutional role and impose upon the nation, quote, their broader vision of what America should be. And that's how he said he would pick judges. And this is certainly the kind of judge President Obama believes he has found in Ms. Kagan, someone who shares his progressive, elitist vision and is willing to advance it from the bench. Indeed, throughout Ms. Kagan's career, she has been more deeply involved in politics than law and has frequently put her politics above law. She's never been a judge, never argued even a case before a jury. She has practiced law for just 3 years. She has less real legal experience than any nominee in the last half century. The experience Ms. Kagan does have, however, is mostly that of a political lawyer and a policy advocate. And whenever her political views have clashed with her legal obligations, her vision of what America should be and not her duty have too often won the day. As a Supreme Court clerk, she pursued a progressive agenda without regard for the Constitution's text or history. She even wrote she was not sympathetic to an American's constitutional right to keep and bear arms. And as a top aide to the President Clinton, she was closely involved in efforts to restrict private gun ownership, including a plan to block firearm importations into our country that one Clinton official admitted was, quote, taking the law and bending it as far as we can, close quote. She also worked aggressively to ensure the wide availability of partial birth abortions. Instead of providing President Clinton with sound legal advice based on the best medical evidence, she pushed the President away from his moderate position, his willingness to reach a compromise on this issue. She even helped revise a medical statement to imply a medical need for the gruesome partial birth abortion procedure that really did not exist. when the expert panel had indeed said it never was an appropriate procedure. Next, as Dean of Harvard Law, Ms. Kagan would once again sacrifice legal principle for political gain or advancement of an agenda she believed in. Ms. Kagan inherited a policy of equal and unfettered access for military recruiters on campus. That was the policy. But she reversed this policy, kicking the military out of the campus recruitment office as our troops at that very time were risking their lives overseas. She did this in clear, knowing violation of the federal law, the Solomon Amendment. The Solomon Amendment, passed by this Congress 4 times, requires unrestricted equal access on campuses for military recruiters. Ms. Kagan knew what the law said, and as she herself admitted, knew that it was enforced every single day she was dean. But she put her own views, her political ideas, her ideology above the law and above the best interest of our soldiers, stripping the military of their official access availability on campus. Ms. Kagan justified this conduct by saying that she was objecting to don't ask, don't tell. That statute, however, was passed by Congress and implemented by President Clinton, her former boss. But instead of complaining to the politicians who made the rule, to those of us in Congress who were involved in passing it and maintaining it, working within the democratic system, Ms. Kagan took it upon herself to defy the law and to demean the people who were merely following the law, our noble men and women who serve our country. Perhaps some of those on that campus recruiting had just come off the battlefield, having served their country, placing their lives at risk. For that, there can be no justification. After Harvard, Ms. Kagan assumed the post of Solicitor General of the United States. In that job, it is her sworn duty to defend all federal laws, including those she may personally oppose. They're laws of Congress the Solicitor General must defend. As every good lawyer knows, her job is to represent her client, and the client of the Solicitor General is the United States of America. Did she fulfill that duty? Did she faithfully represent her client? No, she did not. When the liberal Ninth Circuit issued a deeply flawed ruling against don't ask, don't tell, the law Ms. Kagan had so strongly opposed at Harvard, she did not appeal the ruling, despite great chances of success on appeal to the Supreme Court. Instead, she did exactly what the ACLU, the group who was leading the fight and representing the individuals in that lawsuit, who opposed the statute and wanted it stricken, she did what they desired and let the ruling stand and missed the opportunity to get a clear appeal. This was a test of Ms. Kagan's legal character, and she failed that test. I've studied the case closely. I want to be fair to her about that. The only explanation for her not appealing to the Supreme Court was that she really did not want to uphold this statute to win a victory for the United States. In short, she did not fulfill her duty. Her duty. Is that a word that's out of fashion today? And she did not live up to her explicit sworn promise made to this Senate to vigorously defend that very statute when she was confirmed to be Solicitor General. Given this record, it's not surprising that Ms. Kagan's judicial heroes are activists who reject and repudiate sometimes even the very idea of objectivity itself. But it is objectivity, the search for what is right and true, that make our system of justice so extraordinary and so unique. It's the whole goal of our trial is to find the truth. These concerns were addressed during the hearing. Ms. Kagan was given every opportunity to respond, but she opted, I thought, for political spin at the expense of rigorous honesty and accuracy. In so doing, she only further demonstrated that she lacks the qualities necessary to sit on the court. Other senators have the same impression of that testimony. Some have said that senators are opposing this nomination for partisan reasons, that her qualifications are not in question. But what qualification is more essential for the Supreme Court than impartial fidelity to law? This is not an ideological litmus test, but a core bipartisan standard to which any nominee of any party ought to be held. Senators can and will disagree on the question of how much deference a president is due in his nominations, but surely that deference cannot extend so far as to include a nominee who is unable to serve under the Constitution, as they take an oath to do. The American people will not easily forgive this Senate if we confirm Ms. Kagan to the Supreme Court. They will not forgive the Senate if we further expose our Constitution to revision and rewrite by judicial fiat to advance what President Obama says is a broader vision of what America should be. That's a congressional role, not the judicial role, to figure out what the vision and the policies of this country should be. Now more than ever, we need this court to be an impartial defender of our constitutional liberties. As Vice President Biden's own chief of staff and close friend of Ms. Kagan emphatically said, quote, Ms. Kagan is clearly a legal progressive. And if confirmed, I fear she will continue putting her politics above the law as she has so often before. So I invited those who supported this nomination to refute the record and the analysis that I have stated over really the several past weeks. But I don't think one error has been raised and identified by Ms. Kagan's supporters in what I've said. So we are left with the same core concern, that Ms. Kagan would ally herself not with the constitutional liberties of all Americans, but with the big government agendas of the president who nominated her. In fact, at the hearing, Ms. Kagan was unable to identify any limits on government's power to control America's economic decisions. What Ms. Kagan perhaps failed to realize is that the people should control their government. The people should control their government, not the other way around. That's why no Supreme Court justice should simply rubber stamp any political agenda of a president or Congress, nor should any senator. Our liberties are far more precious than any partisan allegiance. After the Constitution was drafted, Benjamin Franklin was asked what kind of government had been created. Franklin replied, a republic, if you can keep it. Again, the choice is ours. Either we embrace our great, magnificent constitutional heritage that I love so much, or let it slip away to judges who believe that they can allow their own personal core beliefs and philosophies to help them decide how a case should go. Either we move forward more secure in our freedom, or we fall back to the old bankrupt idea of big government, an idea that has failed in every place and every time it's been tried. So let's take a step today in the right direction. Let's listen to the American people, and let's strengthen our commitment to constitutional values. It's that commitment that impels me to vote against this nomination, and why I urge my colleagues in both parties to do the same.